with Tyrone Grayson. Mr. Morgan, can you put your appearance on the record, please?
Stephen Morgan on behalf of the city of Detroit.
We have a situation here where Mr. Tyrone Grayson has a jury trial set for tomorrow. What I wanted to go over with the court, now this is Grayson Bay, let me get that correct. Mr. Grayson Bay, I did receive the documentations that you had. He has a table of contents here. He has a declaration of nationality legal notice, declaration of nationality, name correction, proclamation, public and publication, judicial notice and proclamation to all elected United States Republic office and public servant of federal, state, city, and municipal governments, personnel, and corporate entities concerning the Constitution and all statutory and civil law codes of the land, know all men, etc., know all men be these present. I, Grayson Bay, being duly affirmed, standing squarely, declare and proclaim upon divine law, naturals law, universal law, Moorish birthrights international law, and constitutional law, declare and say, I being previously identified by the Union States Society of North America USA under the colorable warship name Javar.
Buckle in, because what you're about to witness is one of the most unusual court exchanges you'll ever hear. Today, we're stepping back into the legal labyrinth of Grayson Bay, a man who insists he is not the person the court believes him to be. According to him, he isn't Javar Tyrone Grayson. Oh no, that's just a colorable worship name. Instead, he claims to operate under divine law, natural law, Moorish birthrights, zodiac constitutions, and a list of spiritual codes long enough to fill a novel. And he's brought paperwork, a lot of paperwork, to prove it. This case is full of bold declarations, legal arguments that don't quite match legal definitions, and moments where the judge truly tries, to keep everything grounded in reality. But Grayson is on a whole different frequency. He challenges the court's jurisdiction, demands his rights as a Moorish American, rejects a jury trial, and quotes Supreme Court cases that, well, don't exactly say what he believes they say. And that's just the beginning. Throughout this breakdown, we're going to dissect his claims, the judge's responses, the legal misunderstandings, the emotional intensity, and yes, the sheer unpredictability of this courtroom encounter. So sit tight, because every minute gets more dramatic, more confusing, and somehow even more fascinating. And trust me, you do not want to miss what happens when Grayson compares his traffic case to historic civil rights battle.
Publish my corrected national name, declare and affirm my true proper person status, and reclaim my rightful social and cultural life of the state. Semicolon. In accord with my ancestral Moorish nation of Northwest and a Maxims North America acknowledging my birthrights, period. Having lawfully and legally obtained and proclaimed my nationality and birthright name and title, semicolon, I strike that, in harmony with, in association with, and in accord with divine law, the customs and the laws, period, rules and usages of the Zodiac Constitution, semicolon, being aboriginal and indigenous and bound to the North American continent by heritage, by primogeniture, by birthright, by natural birth, semicolon.
From the start, Grayson's approach raises a major red flag for courts, the sovereign citizen framework. These arguments often blend history, spirituality, and misinterpreted legal concepts into a belief system that claims independence from governmental authority. Notice how Grayson confidently presents his documents as if they hold legal power, even though none of them are recognized as binding in U.S. courts. It's a classic hallmark of this ideology: create elaborate paperwork, declare oneself sovereign, and then reject all legal jurisdiction. But the court must operate on actual statute and precedent, not personal declarations. What makes this moment compelling is the judge's patience. He allows Grayson to present his materials fully before making any judgments, something many judges would have shut down much earlier. It sets the tone for a courtroom dynamic that will only get more intense as the hearing unfolds.
European, cognomen, and fictitious misnomer back to the colonial processors of its pedigree, period. I am not rightfully declaring, publishing, and proclaiming my own free national name, affirming my actual, rightful, and civil in full life status, conjoined to my ancestors, Moorish, American, consanguine pedigree, and national honor. Semicolon. Let it be declared, known, published, and resolved that I am Grayson Bay in proper persona sua sui juris, being in my own proper person by birthright. Semicolon. I am Moorish. I'm not going to continue to read the rest of that.
Thank you, Your Honor. Well said, though. Thank you.
I just don't have a clue of what's going on with this.
Just a declaration of my nationality, Your Honor. Thank you, though. Well said, though.
Okay, so, and how? What am I supposed to take of this? You know, are you saying you're not an American?
I'm Moorish American from the
Okay.
land of Exuma, Turtle Island. The issue is the corporation of United States, and that's the issue. And I'm under a natural law as Grayson Bay.
This is where things start to slide into deeper confusion. Grayson uses terms like misnomer, divine jurisdiction, and returning the colonial processors of its pedigree, phrases that sound official but don't carry legal meaning. What's important here is how the judge responds. He doesn't argue, he doesn't attack, he simply tries to extract meaning. The judge asks simple clarifying questions. Are you saying you're not an American? What am I supposed to take from this? These are attempts to bring the conversation back to legal relevance. Grayson, however, remains anchored in his belief system, interpreting identity and nationality in a symbolic manner rather than a legal one. This clash between symbolic meaning and legal reality becomes the central tension of the entire hearing.
Yeah, what I wanted to do was this, because I mean, I'm prepared to rule on some of this without even a jury trial. The only matter that I was really is the false name issue, which is what probably I'll let a jury decide on that, because this other stuff. That's why I had you on. There was an opportunity. These were things that were filed, that he had filed, and I don't know if you've read them or had a response, or I know you probably haven't, but your office. It says, notice to all law enforcement, nationals or citizens are not required to show identification to a police officer. So what I'm going to do, he cited a Supreme Court case, Collender versus Lawson, 461 U.S. 352, 1983. And it says, in which the United States Supreme Court ruled that a police officer could not arrest a citizen merely for refusing to present identification. Now, I'm not even going, did you get arrested, Mr. Grayson?
We see one of the most fascinating contradictions in sovereign-citizen courtroom interactions. Grayson denies the court's authority, yet continues to ask the court for legal remedies. He says he's governed by natural law, but still wants charges dismissed under state law. He rejects the government's jurisdiction, but quotes Supreme Court cases that require government jurisdiction to even apply. What stands out is the sincerity in his voice. He truly believes his interpretations hold legal force. This sincerity creates a challenging dynamic for the court, because a legal system can only function if everyone involved agrees on what the law actually is. When someone brings their own customized legal universe, communication becomes nearly impossible.
Once he touched my vehicle, it's a violation.
Well, listen, I don't recognize your jurisdiction in this court. I recognize the state of Michigan ordinances and laws and the Michigan court rules. So I'm going to conclude that this based on this document that you've given me, this would be your lead case. That I'm not going to consider that necessarily.
Grayson tries to bolster his argument by invoking Supreme Court precedent, which, if used correctly, can be a powerful tool. But legal cases must be applied in the proper context. Collender v. Lawson deals with an unconstitutional law involving vague loitering requirements, not routine traffic stops where officers may briefly detain a driver. The judge immediately notes the mismatch. This is a critical teaching moment. Misquoting or misapplying legal cases is one of the most common issues in these types of arguments. But Grayson treats every citation as universal proof, as though any case involving rights automatically applies to him. The judge's calm, methodical breakdown highlights just how far off the mark this interpretation.
That's your authority that I just read as far as your Morris Nation. I don't understand that.
Your Honor, also I'm not asking for a jury trial. I'm asking for you to make this decision. I'm asking for you.
But I told you that I'm not going to waive your jury trial rights. You're going to let
I don't want a jury trial. I want you. I trust you.
It doesn't matter.
I trust you. I think you can make a firm decision and what's going on here. I'm pretty sure you see.
I'm going to make a decision right now on this stuff right now on most of it. All I told you I'm going to do is the failure to ID.
Oh, sure. I don't want this to hang up now.
The failure, false info, and ID. I'm not going to make a decision on that. I'm going to let a jury make the decision on that.
I'm not really getting an understanding. I don't think you can even find 12 Morris people to even judge me with my peers. I'm not even going to consent to that. So I don't understand.
Well, how are you going to let me? Why do you want me to do it? I'm not Morris.
Well, then you need to file a motion to dismiss this case.
Is that what it is?
Yeah.
It's not going to happen.
Okay.
You got to file those motions on your own.
I'm telling you verbally right now. I'm filing a motion to dismiss this case.
Okay, I'm going to dismiss. I'm not going to grant the motion.
Take it to the next level.
Motion
I'm not paying. That's just it. I'm Morris American, man. I'm Morris American. Okay?
I'm not gonna go back.
That's my birthright.
Listen, I understand that. Listen, I'm not gonna go back and forth with you. I'm not disputing.
Right. I don't even think the prosecutor even wanted to attempt to even battle this. And it's not even against you, Judge. I understand your situation. You wants to be the ref. You can be the referee in this, but I don't think the prosecutor even want to go through this.
All right.
Motion to dismiss, Your Honor.
I'm not gonna grant it.
Okay. Well, do what you do,
Mr. Morgan, go ahead and speak with Ms. Tucker and Mr. Greer. All right.
All right, thank you. Ms. Tucker, can you go back to the breakout room? Just tap your prompt. Tap your prompt, please.
Your Honor, I need you to...
The tension spikes here. Grayson demands that the judge dismiss the case, waive the jury trial, accept his nationality claim, and rule immediately in his favor, all while claiming the court has no jurisdiction over him. These requests contradict each other on multiple levels, but from Grayson's perspective, everything is consistent within his belief system. The judge attempts to explain the rules. Jury trials cannot be waived without proper procedure, motions must be filed in writing, and personal declarations do not override statutory law. But Grayson pushes harder, insisting that his spoken request should be enough. The struggle here is procedural versus personal, legal structure versus individual interpretation. And the courtroom atmosphere grows more strained with every exchange.
Put it in writing, I'll deny it. So let's continue on with this notice to all law enforcement that the Supreme Court case was cited, and I haven't read that case yet, but I'll look it up. There is no such thing as failure to identify. You can sue the police for an illegal arrest and resist arrest with impunity. Okay, so he cited some cases here, State versus Robinson. Looks like a Maryland case. State versus Mobley, in those North Carolina case. State versus Adams versus State, Georgia case. And I guess you're saying on those cases that the person did not have to. You can sue the police, that they sued the police and successfully sued the police for their a wrongful arrest and resistant arrest.
Excuse me. I also have Thompson versus Smith, the right to travel.
Well, that's on the next. I'm going under the failure to identify heading there.
Oh, okay.
That's under the next heading. So the next heading is personal liberty, the right or power of locomotion, of changing one's situation, or moving one's person to whatsoever place one's own inclination may direct without imprisonment or...
The right to travel argument is one of the most frequently misunderstood legal topics in sovereign citizen circles. Grayson believes that freedom of movement means driving without a license or regulation. But the judge does something rare, he reads the cited case out loud. And what does it actually say? That people have a right to travel, yes, but not a right to operate a vehicle without state licensing. This moment visibly throws Grayson off balance. He expected the case to confirm his viewpoint, but instead, it undercuts it. The judge handles the moment professionally, but it's a pivotal point. Factual law and online interpretations often differ dramatically, and here the true meaning is revealed in real time.
Unless by due course of law. Unless by due course of law. Now, I don't know where you got this. If this is a law, you didn't cite anything from that.
It goes on into Thompson versus Smith, the right of a citizen to travel.
Okay, the right of a citizen to travel upon public highways and to transport one's property thereon, either by carriage or automobile, is not a mere privilege with a city, which a city may prohibit or permit at will, but a common right which she has under the right to life, liberty, and the pursuit of happiness.
And I believe I've read Murlock versus.
Hold on, wait a minute. Let's deal with this one right quick. Let's not get ahead of ourselves.
Okay, no problem.
What are you saying? What do you believe this case says?
What we've just witnessed is a prime example of how complex courtroom exchanges can become when personal belief systems collide with established law. Grayson is passionate, there's no question about that. He speaks with conviction, confidence, and a deep sense of identity. But passion alone can't overcome legal standards, procedural requirements, or factual precedent. The judge remained patient, methodical, and respectful throughout, even when the arguments became contradictory or disconnected from legal reality. It's a reminder that the courtroom is guided not by personal declarations, but by structured law designed to ensure